many Shoesmiths have been working with us for many, many years, and each year we have a legal update. And Shoesmiths are represented tonight by Anna Howard and Alex Friston. So please, can I hand you over to Anna and Alex, and they'll go through the presentation. Are you okay with that? Just to let you know as well, we're going to do questions. Please, can you put your questions in the chat, and Alison will read them out at the end. So, welcome.
Thank
Anna
you.
and Alex.
Thanks, Steve. Thank you for inviting us back for this annual health and safety update. Alex and I work in the regulation, business crime and compliance team at Shoesmiths. Today we're going to provide a high-level overview of some key health and safety developments over the past year. So we'll start with a review of the latest HSE stats and their recent 10-year strategy before we move on to talk about some key legislative developments and also some recent case law. We'll also take a look at what might be coming down the track in the near future and share some of the common pitfalls we still encounter and things businesses can do to try and put themselves in the best possible position in respect of health and safety compliance. As you've mentioned, there's an opportunity for questions at the end, and the recording of the session and the slides will also be made available, so people should have those for future reference. So starting with the stats, and I think the most important statistic on this list is the second bullet point down. 51% of work-related illness is work-related stress, depression, or anxiety. Now, that's a really high statistic, and that's undoubtedly why the HSE are going to focus on that, as we'll see when we discuss their latest strategy. And in many ways, it's easier to guard against physical rather than mental health. And that means that companies are going to have to start thinking a bit differently. And there is an ISO standard about managing psychological health in the workplace that businesses could look to bolt on as a management system to help them do that. Mental ill health can often also be more difficult to detect than physical ill health. And if an organisation thinks its numbers in respect of mental ill health are low, that might be the case, but it might also speak to a culture of people not feeling comfortable enough to report mental illness. And that's something that going forward companies are going to need to be really mindful of, and that they may need to address. So sticking with some HSE stats, we can see there that in 2021-2022, HSE completed 290 prosecutions with a 96% success rate for convictions. So in 2016 to 2017, there were twice as many prosecutions as that, but we've seen numbers decrease annually until a low of 206 in 2020 to 2021. So these numbers for 21-22 show a 41% increase in prosecutions from the previous year, but they're still low on years going back a few years. The conviction rate, however, has been the same for about the last few years, so a very high conviction rate. In respect of the third bullet point and enforcement notices, the number of prosecutions has clearly reduced, but as we can see there, enforcement notices are still high. And we also, our experience is also that there is often no real rhyme or reason as to which cases the HSE will prosecute, so nobody can afford to be complacent in that regard. So the HSE's 10-year strategy, again, the main focus here, I think, for most businesses will be that first bullet point, which clarifies that there's going to be a specific focus on mental health and stress in the coming years. So the HSE are going to be building on past guidance for dealing with stress in the workplace, and it's identified mental health and stress as a distinct type of work-related ill health and has committed to focus on that for the next 10 years. The strategy identifies that in contrast to most other types of injury, work-related mental health issues are actually on the increase and are the most commonly reported cause of illness, stress, depression, or anxiety. And every sector of society is impacted by this issue, And HSE analysis calculates that it might be costing the economy up to £11.4 billion per annum. So the strategy clearly indicates the HSE's commitment to support businesses to keep staff mentally healthy and focus its enforcement action on those who culpably fail to do so. So now is probably the time for all, but particularly those recognised as high stress workplaces, to have a review of their policies and procedures in relation to managing stress. It might be necessary to start tracking working hours to help determine which employees are at risk. Companies might want to consider employee support phone lines or mental health champions as points of contact for those who need help. And mental health and stress specific policies can be implemented to document and evidence what the company does to manage and support employee stress levels. Now, bearing in mind that the HSE have specifically called out mental ill health, it seems likely that at least one company in the next 10 years will be handed down a substantial fine for failing to take those measures. So now looking ahead at key developments in 2023, and I'm going to hand over to Alex now to start off with the COVID-19 public inquiry.
Hello, everyone. Thank you ever so much for having us today. I'm Alex. I'm a junior associate here at Shoesmiths, as Hannah's already announced. So yeah, just a bit now about a couple of inquiries. We're just going to cover a little bit about the COVID-19 inquiry, and then to finish off on the Grenfell inquiry. So COVID inquiry, it was set up by the government last year, effectively to examine sort of the UK's overall preparedness and response to the pandemic, and also to ensure lessons are learned for the future. A very much separate inquiry is also being held in Scotland too, but there will be an element of crossover for the one that will effectively cover England, Wales, and Scotland and Northern Ireland. Sorry. Inquiry is being chaired by Baroness Heather Hallett, who's very experienced. She's a former Court of Appeal judge, and she's conducted a lot of different inquests and inquiries over the years. So notable work is acting as a coroner, so for the inquest into the deaths of the victims of the 7/7 bombings in London, and she also chaired the Iraq facilities investigations back in 2019. We're doing quite a bit as a firm on the inquiry at the moment, but often when I take my sort of lawyer hat off and speak to my family and my friends and ask them, what do you know about the inquiry? What do you know about what's going on? A lot of people say, well, I haven't really seen much. There's been very high level bits and pieces in the news, but you will be pleased to know that we are underway with it. It's in its preliminary stages at the moment. So at present, there's only been 3 modules that have been announced, and there's been preliminary hearings for each of the modules. So I'll very quickly just rattle through these. So module 1 of the inquiry is going to be covering resilience in general and the preparedness across the UK. So effectively asking the underlying question of, were we properly prepared effectively? And how was it all planned, and so on and so forth, following the announcement of the lockdowns. Module 2 will be covering sort of decision making, and that's political, administrative, and that's across the entirety of the UK. And interesting one about module 2, it will be split down into sub-modules effectively to assess the effectiveness of Scotland, Wales, and Northern Ireland as very much separate devolved entities. Finally, then we have module 3 at the moment, and that's going to be assessing the impact of the pandemic on healthcare. So anything from healthcare governance and primary care, the backlogs that the NHS faced, the effect on the provision of healthcare by the vaccination programs, and also long COVID too. Effectively, there will be new modules that will be continued to be announced. We have no information on what they're going to be at the moment, but you can expect everything you can think of. So anything from education, the retail sector. Ultimately, the pandemic affected all of us, let's be honest. So I don't think this is an inquiry that's going to go away relatively quickly, if I'm honest with you, no matter what. The commentary on it at the moment is that they'd like to get it sort of wrapped up relatively quickly, and so on and so forth. But yeah, so just a brief one on that. Who might be involved then? So there's going to be lots of different organisations that have obviously been seriously affected. There's 2 different ways of effectively being a part of the inquiry. So you can apply to be a core participant, so you get effectively a full party to the investigations into the topic area, or otherwise you can just be a witness to an event which you may be asked, and you could be compelled to then give evidence to the inquiry, but not necessarily invited to participate in any further modules. In terms of sort of preparation for the inquiry, because appreciating, as I said, we've only sort of had preliminary stages so far, I think the immediate questions that organisations really need to ask themselves is consider if they can afford it. Funding is going to be a big one for this one. Government funding is incredibly unlikely, almost impossible, I would say, for sort of any private sector organisations. So it's worth businesses checking insurance policies carefully, for instance. And I think more personally here, for someone in like the retail or the hospitality sector, it might be worth looking if there was an opportunity perhaps to engage as a group, so with other similar like-minded organisations, maybe an umbrella trade organisation, effectively, so this way that sort of costs can be shared and so on and so forth. I think then just sort of considering representation, early engagement with an experienced legal team, and we'll see how it goes. But at the moment, there's not a whole lot of information at present, so we'll keep a watchful eye on that. Next slide, if you will, please, Hannah. So yeah, just a brief bit now about the Grenfell Tower inquiry. I do recall that we did cover this fairly lengthily last year, coming up to 6 years now, obviously. Wednesday, the 14th of June, 2017. 72 people died that day, so it's an inquiry that we can't just brush under the carpet. It's something that will take a while to conclude effectively. We are pretty much at the end of the inquiry now in terms of the evidence being given. As it says on the side, it was 400 days of evidence, and quite a large proportion of that was during the lockdown periods in the pandemic, and that was when it was all sort of moved virtually. And I think that only sets a good precedent, to be honest with you, for any future inquiries and how easy it is to sort of move into that virtual world for the purposes of evidence and hearings and so on and so forth. So phase 2 of the inquiry, which was the final phase, that closed last July, and then it finally reopened again for some closing statements back in November. And overall, the inquiry, the total figure of the disclosed documents, that was across phase 1, phase 2, was 319,956, and 644 core participants were effectively involved in the entirety of the process. So it's an absolutely massive, mammoth inquiry, and I think that's why questions are being asked now as to when are we going to get the final report, when are we going to get some recommendations. As it says on the slide, it is expected to be spring, sort of summertime this year, but the chair, so that's Sir Martin Moore-Bick, did note last year that he didn't know how long the final report would take to finalise effectively, but preliminary discussions have taken place over the overall sort of shape of the report and the team that will sort of be pursuing the review of all the evidence without delay, which is obviously good news. But a couple of things which we'll obviously go on to talk on briefly in this webinar today, of good things that have come out of the inquiry so far is obviously the Building Safety Act and the creation of the Building Safety Regulator, which Hannah will cover, and the Fire Safety Act also. Thanks, Hannah. Oh, still me. Okay, thank you. So just moving on to a few sort of recent key developments now. Again, do recall speaking about this one last year, but we do have a couple of updates on the Fire Safety Act. So it did become law in England, Wales back in April 2019. Again, as I just mentioned a couple of moments ago, it was introduced following the Grenfell tragedy, and effectively its purpose is to clarify who or whom is responsible for managing and then reducing fire risks in the various different parts of multi-occupied residential building, with the overarching aim effectively to prevent future tragedies happening. And just want to hone in on that point in terms of it is focused on residential buildings here and not commercial, which is obviously often quite mistaken. So, and given sort of fire safety is such a hot topic, pardon the pun, in the world of health and safety, I do recall we mentioned it last year, the sort of overarching piece of legislation, but there's a few bits and pieces that have come into force since last year. So on the as in this session last year, so last year in May, section 1 and section 3 came into force. So what section 1 does effectively is it extends the provisions of the regulatory reform fire safety order, so 2005 piece of legislation, to very specific parts of multi-occupancy domestic premises. And then section 3 of the Act introduces a piece of guidance, risk-based guidance, and that can be found on the government website. I'm sure we'll be sort of covering out in the next couple of slides. Next slide, please, Hannah. So as I said a couple of moments ago, the Act effectively amends the fire safety order, and it clarifies that in buildings with 2 or more sets of domestic premises, the fire safety order will apply to 2 elements, and this is going to be applicable to the duty holder, which will be most often the landlord or the building owner. And effectively, what residential buildings now must do is they must manage the risk of fire, as it says on the screen there, within the bottom 2 bullet points there. So the structure and external walls of the building, so cladding, balconies, windows, and so on and so forth, and then entrance doors. All doors between the domestic premises and the common parts. So it might be entrance doors to individual flats and those that sort of open on common parts. And most importantly, it'll be building owners and landlords, so the duty holder, as I said, who will be held accountable for not complying with the necessary guidelines by the fire and rescue authorities. Next slide, please, Hannah. Thank you very much. So legislation, as it says there, is likely to affect almost 2 million residential properties. So it's a really significant and weighty piece of law. It's seeking effectively to impact risk assessments on construction projects, new build and refurbishments too. Responsible persons though, so again, the duty holder should be mindful of a specific article of the FSO, which is 9.3, to regularly review and update their fire risk assessments if there's ever a reason to suspect it's no longer valid, or if there's been a specific change of a premises to the site. So let's just say if a building's been extended or there's been a refurb. And I think this is something from our perspective, from a legal perspective, that we quite often see. We do a lot of support for our corporate division when they do acquisitions and investments and so on and so forth. And one of the most common breaches that we see for small and medium-sized enterprises are a real lack of seriousness as to their fire safety, no fire risk assessment, no fire alarms drills, and so on and so forth, training. So really, really important area. What also the Act has provided is a bit more of a better clarification on responsibilities. But what it doesn't do, a little bit of criticism from my end, is it doesn't mention who will bear the cost of any sort of historical or future remediation works to premises. So that what that might mean is that leaseholders could unfortunately face the bill for sort of expensive remediation works, which might include something pertinent to Grenfell as removal of cladding, for instance. And then just a final point on this one is some repercussions. So any sort of consequences here for non-compliance with the Act, it's a criminal offence effectively. I think prior to this Act, though, it has been quite challenging to hold certain individuals accountable in the past for fire safety offences. But what this aims to do, and what I hope it has been doing for the last couple of months since it's been in force as a whole piece of legislation, is effectively making it easier for fire authorities to pinpoint that negligence and effectively enforce action where remotely necessary. So some of the criminal sanctions will include unlimited fines and considerable jail term for any sort of culpable individuals involved, and obviously depending on the crime committed. So very sort of similar to sort of general health and safety criminal offences. Thanks, Anna.
Okay, so moving on to the Building Safety Act, the second piece of legislation that Alex mentioned that's arisen from the Grenfell Tower inquiry. So as it says on the slide there, it received royal assent on the 28th of April 2022. And following that, the implementation of it, obviously the aim to reform building safety legislation following the fire, is now well underway. And the requirements that are set out in the Act will affect everyone in the built environment industry, and not just in respect of higher risk buildings, which has received a lot of the focus in respect of this Act, and there is a part dedicated to that, but parts of the Act will have implications for all buildings. So since gaining royal assent, there have been numerous consultations that the government has undertaken, and these consultations highlight the significant implications for the industry. And some of those consultations we have been involved in responses to. And at the heart of the change in the Building Safety Act is the legal obligation for all individuals and organisations to be competent. And that's a real focus and a real responsibility for there to be accountable persons to make sure that that responsibilities don't fall through the cracks, and that all individuals and organisations will be competent to ensure compliance with the building regulations in both the design and construction phases. And crucially, the Act introduces tougher penalties for those who fail to do so. So Part 2 of the Act establishes a new national building safety regulator, and that role is to be undertaken by the Health and Safety Executive. So the BSR will oversee the safety and performance systems of all buildings in England, and the aim is that they will assist in encouraging the improvement in building standards, and once again coming back to competence in the built environment industry. The BSR is also going to be responsible for implementing and managing a new and much more stringent regulatory regime for higher risk buildings. And they'll become the building control authority for all higher risk buildings. They'll oversee the inspection of higher risk buildings during their design and construction. And they'll also have express powers to authorise remedial works to bring a stop to any projects that are going ahead in a non-compliant way. They can impose special measures for failing projects, and they can also order the replacement of key individuals within a project if they feel that that's necessary. So the government guidance in respect of how the building safety regulator will be approaching enforcement suggests that failure to take a robust approach to building safety, and particularly where there have been previous incidents and also enforcement action arising as a result of these previous incidents, are all factors that are going to make enforcement action by the regulator more likely. Part 3 of the Act sets out a proposed regime of duty holders for the design, construction and refurbishment of higher risk buildings. And that's similar to the roles that are set out in the CDM regulations. So duty holders will have legal obligations in respect of their duties in relation to higher risk buildings. And those who fail to meet the key building safety obligations will find themselves guilty of criminal offences. So there are a number of offences under the Act, but just to pick out a few of the key ones. Section 39 of the Act provides that any breach of the building regulations will be a criminal offence. Section 40 provides that where a duty holder is a corporate entity, individuals within that organisation may also be prosecuted where the breach was committed with their consent, connivance, or as a result of their neglect, which again is demonstrative of a trend towards including individual culpability in respect of corporate prosecutions, which is something that we see in this legislation and is an area that has long been seen as something that needs to become more prevalent, that there needs to be more individual culpability when it comes to corporate offending. Section 38 empowers the regulator to issue compliance and stop notices during the design and construction phase of higher risk buildings. And anyone who without reasonable excuse contravenes a compliance or stop notice is guilty of a criminal offence. So although at the moment the secondary legislation is still in development, and it's likely to still be so for at least another 6 months, we have already seen the first enforcement action, which was in October last year, taken by the government against a block owner who failed to carry out the necessary cladding works. And really that should be seen as a warning to the industry that the Act is already being enforced despite not being yet fully implemented. And the regulator has been clear in its messaging to the sector, and that is that it needs to prepare now and play its part in making buildings safer. And that's, although some of the focus has been on higher risk buildings, and Part 3 specifically refers to higher risk buildings, that's regardless of whether a business is working on a higher risk building or not. Now to move on to the impact of Brexit. We're still discussing it years later. As we all know, health and safety law has been around for a long time. The Health and Safety at Work Act 1974 is UK legislation, and that is the starting point for most of the health and safety prosecutions that we see. There are a number of regulations that sit under this Act, such as the work at height regulations, the management of health and safety at work regulations, PPE regulations, etc. And some of these are pieces of European regulation, which is where we will see a potential impact in respect of Brexit. But it's important to remember that, as I say, most prosecutions are under the Health and Safety at Work Act, but with maybe a couple of regulation breaches added on. So the European Union Withdrawal Act 2018, as we know, that repealed the European Communities Act 1972, which had us in the EU, and that ended the supremacy of EU law in the UK. And it converted directly applicable EU law into UK domestic law and preserved UK legislation that had been made to implement EU obligations. And it also created a new category of domestic law, which is known as retained EU law. So most recently, we have had the Retained EU Law Revocation and Reform Bill 2022, which in the brief spell of Liz Truss's government was entrusted to Jacob Rees-Mogg, who was quite keen on progressing that. Whether it will still go through with as much enthusiasm with the current government, we'll have to wait and see. But Retained EU Law was never intended to sit on the statute book indefinitely. But until the bill came in, there was a broad consensus that there'd be a gradual approach of letting this and then subsequent governments review, and if it thought necessary, they could amend or remove retained EU law. And that process could have taken many years, if not decades. The bill, however, brings all of that forward and provides that retained EU law within a defined scope will be automatically repealed by the end of 2023. There is a provision in there that says that this date can be extended to 2026, and in all reality, that is probably likely to be used. Because before this sunset date, whether it be 2023 or 2026, a decision will need to be made by government departments as to which legislation will be preserved in UK law and which will be allowed to expire. There is no comprehensive and reliable list of the retained EU law which would be affected by the bill, but it certainly does have the potential to affect health and safety law. So the bill is still in the House of Lords, and as I say, we'll have to wait and see what form it is finally in when it is passed. But the onus will be on government departments to proactively retain that law, and if they don't do that, then it will automatically expire. But although that is the case, and there is some uncertainty in respect of some health and safety legislation, we certainly don't want anyone to be under the impression that it's it's all going, there's going to be a big bonfire of health and safety legislation. In any event, the Health and Safety at Work Act will remain, and as already mentioned, the majority of prosecutions we see are under that legislation, so that will be unaffected. So essentially, our message to business currently in respect of EU law and the retained EU law bill is just to carry on as they have been, and keep a watchful eye on how things develop over the coming months. I'm just going to hand over to Alex now to talk about the Protect duty.
Brilliant. Thank you very much, Hannah. Yep. So as it's referred to on the screen there, the Protect duty, this is otherwise known as Martin's Law. So that's after a chap called Martin Hett. Martin was sadly one of the victims of the Manchester Arena bombing back in 2017 now. It is still a pending piece of legislation. It will be affecting the UK as a whole. And it's going to be replacing a requirement, on those businesses responsible for publicly accessible locations to consider the threat from terrorism, and then most importantly to implement appropriate and proportionate mitigation measures, which it's hard to believe that there wasn't a law for prior to this. Home Secretary has, excuse me, I just need to have some water. The Home Secretary has actually only just confirmed a couple of days ago that the bill is to be published in the spring. So effectively, yes, it's effectively just when parliamentary time allows. So just a bit more about the duty then. So it was derived through a campaign by Martin's mother, and that was following a consultation period between February and July of 2021. And effectively the overarching reason for introducing the obligation, and this is the words of the Home Office, is to improve security and ensure robust, proportionate and consistent measures at public places to make sure we can better prepare and improve public security. And effectively the new obligations, they were strongly recommended out of the Manchester Arena Inquiry's Volume 1 report, and with the overarching intention of improving the safety and overall security of public venues. So there's 5 requirements that come out of the Protect duty or Martin's Law. The first is a requirement that spaces and places to which the public have access to engage with freely available, and that's on the net, counter-terrorism advice and training. The second is it's a requirement for those places to conduct vulnerability assessments of their operating places and spaces, much like the requirement under the Health and Safety at Work Act to conduct risk assessments like you would for health and safety of your staff. The third one is a requirement for those spaces and places to mitigate the risks created by those vulnerabilities. Fourthly, then, it's a requirement for those places to have a plan in place against counter-terrorism effectively, much like you'd have a plan in place for health and safety and when it goes wrong and so on and so forth. And the fifth and final requirement is for local authorities to have their own plan for the threat of terrorism. And most importantly, and as we saw, which definitely lacked with Grenfell, just going back to Grenfell, is the lack of cohesiveness between local authorities and businesses and the council and so on and so forth. So I think that's what that requirement aims to do, in my view. So taking, I think it's all well and good, sort of, that's the overarching plan of what the bill will include and the reason why. But I think the most important thing we need to say about this is that the bill really needs to take a proportionate and consistent approach to tackling the issue. I know that it will hopefully instill a better culture of security across the board, regardless of the venue type. But just for the purposes of the bill, then the sort of current proposition is that there will be eligible locations captured within what will be legislation. Firstly, buildings. So, and that's sort of collections of buildings as well, used for the similar purposes. So university campuses will be captured, arenas, and then locations and events, so including temporary events. So you might think of something like a music festival, which has a very much defined boundary and a sort of capacity figure attached. these types of locations will then qualify into the scope of the law, where specific qualifying activities then take place. So it is the obvious ones, to be honest with you, to start with. So it would be entertainment, leisure activities, retail will be included, food and drink, museums, sports grounds, any other sort of visitor attractions, places of worship, very importantly as well. And there's how they're sort of ranking it into sort of a proportionality is through 2 tiers. So there's going to be a standard tier and there's going to be an enhanced tier. So standard tier will be applicable to a qualifying location, so it's a building or a specific location, with a maximum capacity of 100. So this might include your larger retailer stores, bars, restaurants. So it is genuinely, an overarching a piece of legislation. But then the enhanced tier, that'll only be relevant to locations where there's a capacity of 800 people at any one time. So your O2 arenas, your football stadiums, and so on and so forth. And I think why we've decided to mention this piece of legislation today is because sort of health and safety as an overarching theme, and fire safety, and where else could we go, food hygiene, sort of many other regulatory obligations, they generally hold companies to sort of standard of what's reasonably practical, so that you've got a plan in place to manage your business and your operations in such a way effectively that is to comply with the law. And it's very obviously rarely acceptable to blame a rogue employee for a failure to ensure that the company has conducted itself properly. So I think what this Martin's Law Protect Duty does is just adds an additional layer of obligation onto a business of a certain nature. And just in case you're interested as well, sort of in cases where there's going to be multiple use or an occupancy buildings, it's quite common for sort of breaches of legislation to exist simply by one party thinking that the other party is doing something and vice versa. Therefore, it's going to be really, really important to be clear from the outset on who's doing what, and ensuring that all the duty holders effectively work together to manage that risk properly. Thank you, Anna.
Thank you. So that is an update on recent legislation. We're now going to take a look at a few cases, and we're not going to focus on just those with the massive fines, but we're going to have a look at some cases that we consider to have a particular point of interest. So starting with Bupa care homes. So the circumstances of this case are that a tree fell on an 8-year-old child as she was jogging on public land past the entrance to the care home in question. When the tree fell, she suffered serious crush injuries, and the result was that her leg had to be amputated. So on inspection, it was found that the tree in question was diseased with a common fungus, and it was actually likely to have been rotting for several years prior to the accident. So the HC investigation found that over a number of years, Bupa care homes had failed to have systems in place around management of trees, such as adequate risk assessments, proactive surveys, inspections, monitoring of trees, in order to identify where remedial work may have been required to prevent that risk of the tree falling. And Bupa care homes, as it says there, pleaded guilty to a breach of Section 3 and received a fine of £400,000. And the reason that this case is interesting is because it clearly highlights the need for businesses to think outside of the box in respect of health and safety. Companies need to be alive to and manage all health and safety risks, not just the obvious ones in relation to their own business operations, but also to consider the premises and the land they occupy, and the risks that may exist there, and they have to take steps to manage all of those as well. The next case is the Office of Rail and Road and WH Malcolm Limited. So in July 2021, WH Malcolm Limited was fined £6.5 million, and that is the largest fine since the definitive guideline was introduced back in February 2016. And the circumstances of this one were that in 2017, an 11-year-old boy received a fatal electric shock when he was able to easily gain access to a depot and to climb on top of a stationary freight wagon in order to retrieve his football. And during a trial which lasted for 3 weeks, the court heard how the investigation found that the company had not only failed to assess the risk of unauthorized access to the terminal, but also failed to implement appropriate measures to prevent unauthorized access to the particular part of the site where there were frequent freight movements and the overhead line equipment was energized at 25,000 volts. The court also heard how the company were routinely placing freight wagons under the electrified lines for prolonged periods of time, and that was despite the presence of a number of unelectrified sidings, which enabled access to be gained to the vicinity of the high voltage cable, which otherwise wouldn't have been accessible. The company had been repeatedly warned about trespassing issues. Higher and stronger fencing had been advised at one point, but the senior team had not done so because they felt it would be too expensive. The company denied the charges and went to trial, but it was found guilty and convicted of an offence under Section 3 of the Health and Safety at Work Act, and another of failing to make a suitable and sufficient risk assessment contrary to the management of health and safety at work regulations. So applying the definitive guideline, the defendant's culpability was high. The harm category was 1, a high likelihood of level A harm. And mindful of the number of children exposed to the risk, the judge decided to move up a category from high to very high culpability. Considering also the effect of the death on sentence, the judge moved to a starting point of £4 million and a range of 2.6 million to 10 million. The judge then considered the mitigating and aggravating factors, as you can see on the screen there. And that led to the imposition of a fine of £6.5 million. The company did try to appeal that, but they weren't able to. So that goes to show the extent of some of the fines that judges are willing to give out for health and safety offences in line with the definitive guideline. Alex, if I can hand over to you for the Brewdog case.
Brilliant. Yeah, Brewdog. So I think the overarching theme of the Brewdog case, I'm just going to go on to prior to talking about it, is ESG. It's a term that comes up a heck of a lot, if I'm honest with you, and a lot of people don't really understand what it is. And it's often a term, well, to start with, it stands for environmental, social and governance. And it's a term that's often used fairly interchangeably with something like sustainability. And then on the other hand, sustainability then is sort of broken down in what I like to say 3 different pillars. And number 1, people. Number 2, planet. And number 3, profit. So it's effectively become a shorthand term for all that's good and green in innovation in industry. It is a bit of a wishy-washy term in my view. So what is it really all about? What does it mean in practical terms? I'm genuinely intrigued, to be honest, whether sort of highly rated ESG credentials are they an optional add-on, or are they a nice to have, or are they genuinely sort of fundamental to today's successful businesses? And I think what we'll do, we'll go on to Brewdog in a sec, which does suggest it's a little bit more fundamental than we think, especially from a reputational perspective, especially with social media these days and so on and so forth. So environmental, very briefly, that's the most straightforward part, if I'm honest. So it's anything a business does which impacts on the environment, and that falls within a definition. So environmental comes first, and obviously for good reason. So we're living in a time of climate crisis and taking place in this race to net zero, I suppose. We as individuals and businesses, we need to live sustainably to ensure that there'll be resources available for future generations. And some businesses amongst us do have a more obvious environmental impact than others. So let's say businesses that operate in waste or in the water sectors, for instance, or those that are regulated by the Environment Agency. All businesses, though, will ultimately have an environmental impact. So whether that's electricity, gas, travel, packaging, products, and so on and so forth. So we all as business have that efficient need for a greater efficiency, and I think that's one of the reasons for the sort of deployment of these ESG credentials. Social and governance, in my view, are slightly straightforward. There doesn't seem to be one singular consensus about what they include. So there is a little bit of crossover. Social, for me, broadly speaking, covers a relationship between a business and its human stakeholders, so employees, consumers, users of the goods and services, whatever a business provides, and also the community in which it operates in. So I think that social encompasses lots of traditional areas of legal regulation. So health and safety, 100%. This is why we're here today, obviously. Human rights, modern slavery, and then there's sort of vaguer concepts, community relations, individual accountability, business transparency, and things like that. So it's going back. It is quite a wishy-washy term. And someone will say ESG and they'll say something completely different. It'll still be right, or of their opinion. I think governance, though, is probably one of the hardest to define. At a very high level, it relates to the culture of a business, which is obviously very important and pertinent to how we approach health and safety as professionals, and also the moral code that a company operates. So considerations of the governance side might include your board structure and how boards of directors are held accountable, especially with sort of health and safety offences. It's not just the companies that are that got on the hook. It's the individuals too. How businesses are audited and the sort of management of any sort of corruption issues too. So that's ESG as a whole. Apologies if that went on a little bit. It's BrewDog itself. They have faced some challenges. I'm sure a number of you have heard, because it has been over the news in the last couple of years. So the company was dealing with some concerns of employees and ex-employees. As it says there, it was 250 whistleblowers who complained about the company's culture. They did lose their status as a B Corp company, which is a company effectively, as it says there, balances business and profit with people and the planet. Apologies for the slight typo there. But effectively, an open letter was signed by a number of former staff that claimed that the overall working conditions of the company effectively caused them to suffer mental health issues. The letter was then published on Twitter, and as you know, when something goes on Twitter and it goes viral with likes and retweets, it's pretty much game over, especially with cancel culture and so on and so forth. Signatories of the letter even went as far as saying that their treatment was inhuman. So I think the whole, just sort of rounding this slide up, the point of this is company culture and health and safety is so important, because if you're a massive company like BrewDog, it's a very popular beer company with lots of different age groups and so on and so forth. Once people got wind of this, it really did affect their sort of reputation overall. And that's everything on that one, Hannah.
Yeah.
I think we're back to me. Yep. So common pitfalls. So I think just going back to that. Sorry, that's the next slide. Apologies. So common pitfalls. We've got a number on the screen there. It is about when things go wrong. That there is obviously always that benefit of hindsight, but accidents obviously do happen. None of us are infallible, and I think that's why, to be honest with you, there is that sort of due diligence defense that companies have. But overall, we do need to guard against mistakes. So if you do take anything away from this training, I think it's, for me, it's actively implementing systems. I get it. There's going to be plenty of paperwork in place, risk assessments, and lots of different steps, as you can see on the screen, to prevent those accidents. But those steps do need monitoring, and it just goes back to the sort of corporate support work we do as lawyers here at Shoesmiths. A lot of the time we see plenty of policies and procedures on paper from a desktop perspective, but ultimately when an auditor goes in, real life makes a practical assessment of a business, it's often not quite what it seems. So I think Sorry, apologies. Yeah, was just staying on this slide for a second. So just a few little pointers, which are obviously on the screen as well. So let's just go poor perception of risk, for instance. So making sure that you as a business, are you actively involved in making those risk assessments effectively? A cursory glance and, you know, just a once a year or once a 6 months is not really good enough in 2023, to be honest with you, for the purposes of the regulator and what they'll be looking for. You need to ensure that effectively they're fit for purpose. In terms of inadequate communication of systems, you need to identify from a very, very early stage who's going to be responsible and are they a sufficient person or persons, apologies, to have in place. Unfamiliarity of the workplace, 0-hour contracts, obviously still quite popular and or similar. Agencies and temp staffs is at risk. You know, are they trained ultimately, and who are they trained by? And when I say trained, I don't mean going into a business and having to sign something where, you know, a 20-page document that they've purported to have read in 30 seconds and signing a bit of paper. That's not training. That's not sufficient training at all. Wrong equipment for the job is obviously on there. Just going back to that training point, it does say there about inadequate training. So, you know, is refresher training fit for purpose? And it's always good to take sort of individual knowledge and competencies into account, which will obviously vary quite widely. And I think everything else there is fairly straightforward, if I'm honest with you. So this is also me, Horizon, so apologies. So 2023 and beyond. So it's interesting you said, it says on the screen there about mental health and well-being, definitely continues to be high on the agenda, especially based on what Hannah said. Just an interesting one from me. Health and mental health in terms of the sort of health and safety legislation isn't specifically identified, in my view, in our UK legislation. But it was really interesting. We were recently instructed by a Australian law firm who were asking about psychosocial risk in the workplace and effectively what can be done to identify that, and the fact that in Australia there's a massive amount of increased scrutiny at the moment on regulators on the sort of overall mental health of workforces. I think it's best here to have a look into the Health and Safety at Work Act, because what employers do have that duty to do is so far as reasonably practical, as I know it says, is to ensure the health, safety and welfare of all employees at work. And I think this is purposely broad, it is purposely all-encompassing, and I think it would have an overarching coverage of sort of psychosocial hazards and risks that are associated with that. A couple of other things on the horizon, not on the screen there. The online safety bill that was introduced in the House of Commons last year, I think it was last March, came back of this January, so it's quite a fairly recent piece of legislation, and it is due to be debated in House of Lords later on this year. Aim of the legislation effectively is to protect users of online content sharing platforms. That'll be both children and adults, and that's from sort of harmful material. And there'll be a lot of more legal obligations on social media companies and tech companies, and so on and so forth. Thanks, Hannah.
Thank you. So just finishing off with this then, what businesses can do now. As it says there, tone from the top, attitudes to health and safety are determined by bosses, not just the organisation size. So it has to be a top-down approach, and it has to be a culture that becomes an instinctive part of a company. We've put on there the 5 C's commitment. Where does safety fit into management priorities? Competence. How does staff feel confident with their training? Is their training fit for purpose? Control. Does everyone know their responsibilities? Is there no blame culture? Is openness encouraged? Cooperation. Are people involved? Do they understand the risk assessments? Are their opinions valued and listened to? And communication, find out what staff really think about health and safety. You don't want the first time you find that out to be when they're being interviewed by the HSE, and your perception of how health and safety is varies wildly from that of your staff. And finally, we've just put on there, plan, do, check and act. And the one where we see most commonly that there's a downfall is the check. So make sure, like Alex said, plans have been implemented. Paperwork on its own isn't a particularly good performance measure. Assess how well the risks are being controlled and if you are in fact actually achieving your aims. Audits, that sort of thing, can sometimes be useful. And investigating the causes of accidents, incidents or near misses in order to learn from those and make sure that systems are operating as they should be. I'm conscious that we are now at an hour, but perhaps we can stay for 5 minutes just to take any questions that have come through.
Thank you so much, Hannah and Alex. That was brilliant and really broad ranging. We've got a couple of questions in the chat, so if anyone has a burning question but hasn't put it in the chat, now is your moment. Stephen, do you want to unmute and ask your question about mental health illness not being RIDDOR reportable?
Yeah. I noticed that still under RIDDOR, mental health is not RIDDOR reported, and I was wondering if that was ever going to change with the numbers that's happening.
I think when it comes to the time of absence, so RIDDOR reportable incidents where someone has been absent for a period of time as a result of it, I think it's likely to be caught by that. So although it's not a specific listed injury like a fracture, if mental health illness causes someone to be absent for the required amount of time under RIDDOR, then I would have thought that it would be captured by that and would be RIDDOR reportable under that provision. And when you're talking about stress, those sorts of things are likely to be more long-term absences than some of the physical injuries we see. So I imagine that most of them will fall under that category.
Yeah, I have to agree with that. And there's a lot of traction at the moment from legal commentators that RIDDOR reports in the future, at least, should definitely start to include mental injury rather than just sort of physical.
Thanks for that. Yeah.
Great. A question from me. I'm really interested to know if we're seeing any prosecutions that we link to our changing working patterns during lockdown. So one of the things I picked up was that you said the 27% of the reported work-related ill health or musculoskeletal disorders. Were any of those linked, for example, to working from home, or were they the more traditional kind of injury statistics that we're used to seeing?
Yeah, so I'd say I don't know the specific breakdown of those musculoskeletal injuries, but certainly assessing the working environment, the remote working environment, is certainly something that companies need to be mindful of, and to ensure that they do have policies in place to make sure that they have assessed that people's work environments at home are suitable and aren't going to lead to injury. And the remote working, I think, also feeds in as well to the mental health aspect and how easy it is to monitor the health and the mental health of your staff when they are working remotely. And again, that's something that companies are going to have to grapple with and make sure that they're satisfied that they have policies and procedures in place to keep their employees safe, even when they're working remotely in their home work environment, that the company isn't unable to influence and manage as well as they can the actual office work environment or whatever the actual workplace environment is.
That's great, thank you. We've just done. I'm going to come to another question, but I'm just jumping forward slightly because one of the comments in the chat is saying that guidance says stress isn't RIDDOR reportable as it may not be attributed to a single event. Is that kind of where part of the tension about the reporting might lie?
Yeah, potentially, and I suppose, you know, something doesn't have to be RIDDOR reportable for the HSE to look into it. But that is something potentially for us to look at further about the RIDDOR reporting requirements when it comes to stress, and whether that is captured by the legislation, and if not, with the HSE stating that their focus is going to be on stress and mental ill health in the future, whether that's then amended to ensure that it is captured by that legislation.
Would I be right in thinking, I'm saying this more off the top of my head, have there been prosecutions around stress historically?
I certainly haven't been involved in any RIDDOR in any HSE prosecutions involving stress. I don't know, Alex, whether you have.
No, I haven't either. It's a really good question though, but it is definitely something that I'm sure we will see in the next couple of years and beyond, if I'm honest with you.
Brilliant, thank you very much. Really interesting point being raised here. One of our attendees is saying they've experienced pressure being applied via work WhatsApp group, and asking what's the experience of this. And I guess that's the kind of currently always evolving things, isn't it? That businesses use different platforms and technologies, and then the pressures and the influences follow along behind that. Is that something we're seeing in the legal forum?
It's not something that I've personally seen, if I'm honest with you. So sorry to single you out, Matt, but is there could you give some further background on that if possible? Feel free to do it on the chat, or if you wanted to pick up afterwards, happy to, of course. But it's not something I've seen personally. How about you, Hannah?
No, but I wouldn't be surprised if, like you say, that's something that starts to become encompassed when we start to look at work related and what is work related, and WhatsApp groups becoming work related.
Matt, I'm on my way to unmute you. Matt, you should be able to unmute now.
Yeah, can you hear me?
Yeah, we can hear you.
Great, thanks. Yeah, just a quickie. Prevalent in manufacturing, but it's probably not just manufacturing. There's lots of groups, aren't there? There's the production, there's the engineering, there's the leaders of engineering. They seem to grow. When you look at them sort of from a distance and with sort of a logical mind, you can see how they escalate really quickly, and people are never off. I just wonder if that's going to, find its way into the system in terms of one of the factors that contributed to someone's having some sort of mental health episode.
Yeah, and that's when we talk about companies implementing policies and procedures, about looking at their staff and trying to make sure that they understand the pressures that they're under, and looking at absence and looking at any of those factors that might make somebody more at risk for suffering work-related stress. And like we say, having mental health champions, having forums and implementing a culture where individuals feel they can come forward if they do feel that they are under too much pressure or stress before it gets to the point of it making them unwell. And those are the sorts of areas that companies will have to start looking at in order to make sure that they're seen to be doing everything that's reasonably practicable to prevent work-related stress in their workforce.
Just very quickly to add to that as well. I think with WhatsApp, and I know it's a great communication tool for all of us. I'm sure we all use it on a personal basis, but what businesses have to be really careful of is the privacy issue. GDPR is a big one, so it's ensuring that they're keeping that on their internal platforms as well, and not sharing information that they perhaps shouldn't be sharing on WhatsApp in groups and so on and so forth.
Good point. Thank you for that. I'm not seeing any more. I'm seeing lots of people saying it's been a great session. So thank you very much.
Thank you.
Appreciate your time. Thank you.
No, we really appreciate it. It's always one of our kind of annual highlights is our legal update. So thank you very much. Stephen, can I hand back to you?
Yeah, that's great. Look, Anna and Alex, thank you so much for a very professional presentation. You've given us good guidance on the legislation with the COVID-19, the Grenfell, the Brexit, and obviously the protect duty, and then going through the cases was particularly interested in that WH Malcolm Limited offence. I was on a site only 3 weeks ago, and I noticed that the client, I won't mention the client, it's a big company, they had a fragile roof, there was roof lights, and I had to say to them that you have not warned people that that's a fragile roof. And if thieves broke in and went through the roof light, they could sue. And they were dumbfounded by the law.
Yeah.
But you've got to warn people of the hazards.
Yeah. Especially if it's in a high risk area such as railway lines, which are known to be trespassed upon, and particularly by young people, and you have to be aware of the risks and the duty that is owed even to trespassers. So yeah, that's sort of highlights that well for people.
Yeah, that's great. And I know, Anna and Alex, you work for the HSE. You do defence of potential offenders as well. And I know you did one for me when I was in the HSE in Colmore Road for the illegal removal of asbestos. Now that's going back to
I was going to say, when was that?
2011. You're probably still in school.
Not quite for me, but yeah, I think it tends to be more defence work for us these days than HSE prosecutions. But yeah, lots of health and safety cases.
Brilliant. Are you still in Colmore Road? That's not where the asbestos was, but I know.
Thank God.
You're very near to Colmore Road. Are you still there in Colmore, near Colmore Road?
Yeah.
Yes.
Soon to move though, so I think we're moving to new offices in May. So yeah, still there for now, but not for too much longer.
Okay. Well, all I'm saying to everybody on the call, if you have any problems, legal problems, maybe Shoesmiths can help you out. They're very experienced in that side of it. But again, can everybody give you a thank you to Anna and Alex? I know I always look forward to the legal update, and it's brilliant. And I know we talk about stress, and there's you helping us out outside work time, but I know you enjoy it.
Yeah, well, yeah. Thank you everyone for your time and for having us, and sorry for overrunning slightly. But yeah, hopefully it's been useful, and everyone can go and enjoy the rest of their evening now.
Great. Thanks. Thank you very much, Anna and Ali.
All right.
Thanks
Take
all.
care.
Bye
Thank
now.
you. Thanks.
Bye then.
Bye.